versus John Bassett et al. Will parties please say your entry appearance?
This is Adrian Terry. I am the attorney for the plaintiffs in this action.
Good afternoon, Your Honor. Paul Kennedy from Marcus Royale. He appears personally.
Good afternoon, Your Honor. Mark Lowry on behalf of John Bassett, who's present in the room with me in Albuquerque.
Your Honor, Daniel Mackey, also here for Mr. Bassett.
Great. Audrey Jaramillo, counselor of the town of Edgewood, Counselor Sherry Abraham, town of Edgewood, USA.
Okay, I think we have everybody has entered their appearance. In this matter today, we have scheduled a couple of items. One was the defendant, Marcus Royale's motion to set aside the default judgment, and we also have the petitioner's, the plaintiff's guilt motion in order to show cause. And before we move into that matter, as with every hearing that we've had in this case, there's always something filed at the time of the hearing, which changes the course of the events. For the record, I have received John Bassett's notice of judicial qualification and entry appearance by Mark Lowry, and a response now is expedited. Motion in order to show cause to hold and declare defendant John Bassett and Mark Royale in civil and criminal contempt. So before we proceed to that, the court wants to clarify. I understand there's been writs filed with the higher courts in this matter, and I think it would help all parties, including the courts, to have a clear recitation of the events that have taken place, because things have been moving rather fast in this matter. And I want to, and as before we could move forward with these items set, clearly delineate what has taken place in this matter to this point. On October 27th, the court held the motion to set aside the default judgment, which had been filed by the defendant Royale in this matter. At the hearing on October 27th, the interveners filed, Audrey Jaramillo and the other intervener had filed a motion to intervene. And at this hearing on the 27th, there was a conflict of interest raised by the interveners whether Marcus Royale should be representing the town or Mr. Bassett, as indicated. With the conflict been raised at that time, and that only count 3 pertained to the town of Edgewood, the court deferred hearing the defendant Marcus Royale's motion to set aside the default. The court found at that time that I ordered that the matter go back to the town council to make a determination in light of the crowd. Yes, hello? Yes, who's there?
I'm calling in for a 10-year review case for Paul Cook.
Okay, if you could disconnect, and I will have my TCA contact you with the new date that has been rescheduled. Thank you, ma'am. You may hang up at this time, and my trial court assistant will give you the new court hearing date. Okay, it was rescheduled.
Okay, thank you.
Thank you. I apologize for the interruption. As I was stating that at this hearing on the 27th, the issue of conflict was raised before the court by the intervener, saying that there was a conflict between Mr. Royale and the town of Edgewood as to the nature of the complaints, and that only count 3 related to the town of Edgewood. This information being brought to the court deferred hearing defendant Royale's motion to reconsider default and ask the court to make a determination in light of the conflict raised whether they wanted Mr. Royale to continue their representation. And the court then issued an order of the interveners which reflected the court's ruling Then the court set the matter for the defendant's motion for default judgment for November 4th. And at that time, the court was ready to hear the defendant Bassett's motion for default judgment and defendant Ryall's motion for default judgment for consideration of the default judgment. The court then received the motion order show cause that was filed by the plaintiff. It was filed the night before the hearing. In light of the motion order show cause, which raised the issue whether there was an issue that the standing of Marcus Ryall was valid by the vote of the town council. The court did not entertain the motion order show cause to allow Marcus Ryall enough time to file his response and for a determination whether, in light of the motion order show cause, Mr. Ryall had the standing to present the town of Edgewood in the matter of requesting to set aside the default judgment. Those are the reasons that the court did not entertain Mr. Ryall's motion for default judgment, and it was due to the issues being raised to the validity of Mr. Ryall's standing as counsel, which was raised in the first issue of the conflict of interest, and in the second matter was raised in the motion order show cause. So I want to make that clear, the purpose for not hearing Mr. Ryall's motions at this time, and now I do have that scheduled before the matter of the court. However, we do have the motion in order to show cause, which is also pending by the plaintiffs, and we also have the notice of disqualification and the response which has been filed by defendant Marcus Ryall. With that being said, Mr. Lowry, do you want to proceed on your notice of disqualification? You're going to have to unmute yourself, Mr. Lowry. Star 6, please.
Thank you, Your Honor. As was stated, the notice of disqualification is self-executing under the statutory provision and the case law, in long-standing case law in New Mexico, that once an affidavit by a party disqualifying the judge has been entered, that, and I'll quote Rivera v. Hutchins, the filing of an affidavit of disqualification, quote, ipso facto divests the judge of all further jurisdiction in the case, and subsequent proceedings are without jurisdiction and null and void. So, Your Honor, based on New Mexico's current case law, this case falls squarely under the provision of 38-3-9 being a claim of indirect criminal contempt as forwarded in expedited motion for an order to show cause. We argue that the court is without jurisdiction as to John Bassett to continue with the case, and that the case law is clear on that.
Mr. Sherry, your response?
Thank you, Your Honor. My response is threefold. Here is the first issue. The first issue is the statute under which Mr. Bassett has filed his affidavit of disqualification. It does have a canon of case law behind it. And what is most notable about that canon of case law is it says that once a party has filed a document with the court and has invoked the court's discretion, that the party can then no longer excuse the presiding judge. So if Mr. Bassett wanted to file this affidavit of disqualification, he needed to do it before he requested any relief from the court. Instead of doing it at that time, on November 2nd, what he filed was an emergency motion to stay the execution of the writ and to set aside the judgments against it. So he's invoked the jurisdiction of the court, requested the court to exercise discretion, issue a ruling on his motion, so therefore this affidavit of disqualification is untimely. Second prong is that the statute that is referenced by Mr. Bassett through his attorney is really a corollary to the Rules of Civil Procedure 88.1 about peremptory excusals, because that's essentially what they're trying to do is exercise a peremptory excusal of Your Honor without cause based on the filing of this affidavit, which they claim is self-executing, which is similar to what the process would be under the Rules of Civil Procedure. But it's noteworthy that if you look at Rule 88.1, one of the things that it says is that no party may excuse a judge after they've attended a hearing before the court, and Mr. Bassett has already attended the hearing through his counsel, Dan Mackey, on November 4th, so last week. And it says that no party can excuse a judge once they've requested anything from the judge other than a free process, so they don't want to pay a filing fee, or requested an affidavit of indigency. So those are not the scenarios here, so he doesn't fit under the rule. In addition to that, it's noteworthy that we're in strange times. This is COVID-19. We've got a pandemic going, and the Supreme Court has issued supplementary emergency rules, one of which is that you can't peremptorily excuse a judge. So I think that those are the obstacles on that front. The third thing that I would say, and this is perhaps the most important prong, is that what Mayor Bassett is saying is that because this case involves criminal contempt, that he has this right to excuse the judge. Well, I would argue that those are not exactly the facts, Your Honor. What we have here is we have this motion for order to show cause on contempt. We're here before the court, and I think what the court has to determine today is, number one, whether you're going to impose sanctions against either of these two contempt defendants, payable to the plaintiffs, presumably, for civil contempt. If the contempt defendants are unable to give adequate explanation for their defiance of the court's orders, then there is a strict procedure under the rules, and this is Rule 93 for criminal contempt. And what it provides is that if their explanation is inadequate, that Your Honor will initiate the filing of a criminal complaint, which is subject to the rules of criminal procedure, will go through the criminal course on a criminal docket, and the rule is explicit that this criminal contempt proceeding will be docketed as a separate matter and with a new case number. So the affidavit of disqualification that Mayor Bassett might be trying to file in relation to criminal contempt is certainly something that he can. He's just filing it against the wrong judge and in the wrong matter, because we haven't reached that point yet.
All right. Anything else on that, Mr. Lowry?
Oh, sure, Your Honor, quite a bit, actually. Mr. Terry, in his first 2 points, tries to dodge the plain reading of the statute at issue and claim that this is a preemptive challenge to the judicial authority in this case. And this clearly is not a preemptive challenge, which would... Pardon me, I'm just getting some feedback here. But this is plainly not a preemptory challenge, because preemptory challenges, A, need to be brought at the very beginning of the case. I'll agree with plaintiff's counsel on that. And B, preemptory challenges have been eliminated by the COVID order number 25 entered by the Supreme Court on July 6, 2020, which is why plaintiff's counsel is artfully trying to claw this case back under Rule 88 of the Civil Rules of Procedure. Clearly, if you look at Rule 88, there's no discussion in the rule about indirect criminal contempt allegations or charges arising within a case. And that is because it is a preemptory rule, meaning you get to choose your judge at the beginning of the case. But what the statute 38.3-9 clearly contemplates is once a case is underway and there is a party, as plaintiffs have, moved for contempt sanctions, that if those sanctions are based on indirect criminal contempt, that the defendant of those charges has the right and the opportunity to disqualify the judge in that matter. And that is not something that's contemplated under Rule 88 whatsoever. And so Mr. Bassett has clearly complied with 38-3-9 and 38-3-10. And going to the timing, Mr. Bassett can't be clairvoyant and understand at the beginning of the case that plaintiff's counsel is going to move for criminal contempt during the transition of the case. So I think that argument sort of falls flat on arrival. And B, what we have here is clearly a situation where plaintiff's counsel has moved for criminal contempt sanctions. And in fact, I mean, he talks about this Rule 93, which I totally agree with, if the court was going to contemplate moving forward, but of course, the court's divested of authority under the statutory authority, not the rules of the court, but the specific, the court's divested of the ability to make a ruling on that for a couple of reasons. A, the plaintiff's motion isn't verified, and there's long-standing case law in New Mexico that requires a motion like this to be verified and sworn before the court could even go here. And so we have a jurisdictional deficit on plaintiff's part right out of the gate. And I'll cite Escobedo v. Agricultural Products, Inc. at 86 New Mexico 466. It's otherwise 1974 NMCA-063, and if the court cares to look at that case in paragraph 49, the court talks about, any motions by counsel seeking sanctions have to be under oath, and that any proceedings flowing from such effective motion lacks jurisdiction to proceed. So there's a problem there. So what Mr. Bassett has recognized is what the legislature has conferred upon him is the right to disqualify the court when there's been a criminal contempt brought to the court's attention. And that's something that the statute clearly contemplates. And that clearly what we see here is the plaintiffs are trying to run away from their criminal contempt allegations in their pleading now that we brought this to the court's attention. And I think it's fairly obvious if you look and examine the plaintiff's motion, nowhere in this motion is Rule 93 cited. And in fact, what the plaintiff actually requested in their prayer for relief is the court to move directly to criminal contempt penalties. And if you look at the prayer for relief on page 12 of plaintiff's motion that was filed on November 3rd, 2020, I mean, they asked this court, Your Honor, to enter an order requiring defendant Bassett why they shouldn't be held in civil and criminal contempt. Enter an order for Mr. Bassett to disgorge and reimburse for the cost of inexpensive legal services provided. And then enter an order restraining Mr. Bassett from engaging in the business. And so when I take that back, they do talk about Rule 93 at the very, very, very end. It's to enter an order for the court to take such actions necessary to initiate a criminal complaint. But, Your Honor, what we would seek at this time is that even to get there, Mr. Bassett has the statutory right to disqualify Your Honor, so a separate judge can analyze the request, the deficient request made by plaintiffs because it's not verified, to see how this case could proceed. The plaintiffs also allege that because Mr. Bassett filed a pleading on the 2nd of November, that somehow he's disqualified, preempted from responding to a pleading that was unforeseen that plaintiff's counsel filed on the 3rd. And again, this comes back to the timing issue, which, again, Mr. Bassett isn't clairvoyant. He had no idea that plaintiff would move for civil and criminal sanctions, and therefore I think the argument just fails under the statutory language. And finally, Your Honor, this motion to disqualify isn't merely based on the statute. It's also based on the constitutional requirements of due process of law. And what the New Mexico courts have long recognized that any litigant in New Mexico courts are entitled to a fair and impartial tribunal when a judge is presiding over their case. And unfortunately, in this case, if we look back to what's transpired in terms of the court excusing plaintiff from following the very basic fundamentals of civil procedure, not serving Mr. Bassett with the first amended complaint, not providing him with personal service, not establishing personal jurisdiction over him, and then moving to default against Mr. Bassett, and the court granting the default proceedings in light of the motion to reopen the case, denying that, in the face of historical New Mexico case law painfully disfavoring default judgments and honoring resolutions of cases directly on the merits, especially when Mr. Bassett had every legitimate reason not to respond until he was personally served, shows an unfair bias against Mr. Bassett that deprives him of a neutral and impartial judge presiding over his case. So what we're saying here is this isn't just a statutory claim for disqualification, but this is also a constitutional claim, and it's one that's recognized under the Due Process Clause of New Mexico's Constitution, as well as the Code of Judicial Conduct. And finally, Your Honor, as to the timing, I just wanted to come back. If you look at the commentary under the statutes, what you see is once there's a motion for contempt filed, that the disqualification is considered timely based on the movement of a party to file for that kind of contempt sanction. So, Your Honor, we hate to come and rain on the parade here, but Mr. Bassett's position is that this court's without jurisdiction to continue hearing the case against him, and that Your Honor cease and desist from doing so and reassign this case to a different judge and allow the plaintiff, as to Mr. Bassett, to file an appropriate pleading if he cares to proceed, so a neutral and impartial judge can decide the matter. Thank you, Your Honor.
Thank you, Mr. Lowry. The court has reviewed your request in the affidavit and has heard the arguments, and in your position to request that the court be disqualified, the court finds that you have not shown that the court has exercised any bias towards or against your client. The court has made a decision which may be favorable or unfavorable to your client, but is made a decision based on what the law has presented you. The proper remedy, of course, is being taken to pursue any concern with the higher court, and that's the course of action to take in this matter if the parties disagree with this court's rulings. Mr. Lowry, you've raised a different issue of jurisdiction. You've thrown it into the argument of disqualification. However, that is a separate issue from the request for disqualification. So based on the request for the court disqualifying, the court is going to deny your request for disqualification. This court hear the contempt and finds that it is premature. The plaintiff is asking the court to make the determination whether this is civil or criminal. The court has not heard anything related to this, and if you have jurisdictional issues, you should raise those, Mr. Lowry, but that is separate from asking the court to disqualify itself because the court has not heard this motion at this time. And as you are aware of, jurisdictional issues should be raised prior to a hearing of these motions, and the court has not seen this issue raised until now you've raised it towards my disqualification, but that is a separate and distinct issue. So I am denying finding that that you have not shown that there is any bias, and that also this is more of a preemptory excusal, which according to the COVID regulations, the court is not allowing the preemptory excusals to be allowed at this time. So for those reasons, the court is denying your motion, Mr. Lowry. Now the next item, and I would ask Mr. Chair if you could draft that for the court and circulate it to Mr. Lowry and get that back to the court by the 16th next week. Thank you. Okay, the other item we have is the Mr. Rael, I want to ask you, as far as proceeding, are you wanting to proceed with your motion to set aside the default judgment today?
I'm a little surprised. I wasn't sure you were going to allow me to argue the motion to set aside the default judgment based on your Honor's statements at the last hearing. I am ready to proceed with that argument if your Honor is ready to hear it. However, at the last hearing, you stated that Mr. Terry's allegations against me prohibited you from hearing my argument on my motion to set aside the default judgment. So I am ready to proceed, Your Honor, if you've changed your mind based on what Mr. Terry's motion was at the last hearing.
I understand, Mr. Rael. That's why I laid this out early on. I understand there's some confusion among the parties as to the process of the motion and filing subsequent to the hearing. The hearings have been taking a different form because of the late filing of motions presented to the court. However, the court did delay as I stated earlier, your motion to set aside the default judgment due to the motion and order to show cause sanctions, and that was to allow you an opportunity to respond to make a determination if this was valid authority for you to represent the town and to proceed in that matter. My question to you is only to clarify if it is still your position today, and there was confusion, if you're willing to proceed if we get to that point. We will hear the motion or show cause first and then allow you, Mr. Al, if you are ready to proceed with your renewed motion to set aside the default judgment. Okay.
Yes, sir. I'm ready to proceed if we get to that point. However, I'll let Mr. Justice Kennedy speak to the prior motion.
Okay, very good.
Thank you.
Mr. Terry, are you ready to proceed with your motion or show cause?
Yes, Your Honor.
Okay, you may proceed, Mr. Terry.
Thank you, Your Honor. I was not sure how you wanted to proceed on this motion today, but I'm happy to take the floor. A couple of comments is that either number one, I thought that perhaps either the court would conduct an examination of the contempt defendants, which would be John Bassett and Marcus Rael, about whether or not they complied with the court's existing orders, including specifically the court's October 30th order, or whether you wanted the contempt defendants to make an affirmative presentation about whether or not they complied with the court's order. But I'm happy to lay out the material facts. We are only discussing a 14-day window of time. It's from October 27th to today, 2 weeks from Tuesday to Tuesday. In the October 27th hearing, the court made certain rulings from the bench. Those rulings were memorialized in a written order that was filed with the court on October 30th. That order had specific itemized decrees from the court, and we'll get to those in just a moment. Part of the court order required the town to have a meeting. This was the request of the interveners, to have a meeting to determine how they wanted to proceed in this action, who they wanted their attorney to be in the scope of that representation, and whether or not the mayor, after he was removed from office, was entitled to any defense by the town. That meeting happened on Monday, November 2nd, just the turn of the weekend. The problem with that meeting, as I noted in the prior hearing, Your Honor, is that John Bassett participated as mayor. And John Bassett voted as mayor. And all of the actions that were passed or purportedly passed by the town's governing body was on the affirmative vote of 2 town councilors and then the mayor who broke the tie. My contention is that under the court's orders, Mr. Bassett was not allowed to participate in that meeting. I think that that's clear from the court's order for default judgment. It says judgment is entered against John Bassett on counts 1 through 6, excluding count 3, because that's only as to the town. To me, that seems self-evident. Then there was a subsequent order of judgment against Mayor Bassett, the summary judgment, which says that he's deemed that there's a judgment against him on count 2 for violation of the nepotism ordinance. Obviously, these issues weren't tried on their merits, but they're still judgments of the court. And they have full force and effect until they're lifted, vacated, reversed, something. But the court's October 30th order was extraordinarily explicit and was clear that the mayor had been removed from office. That was in paragraph 10 of the court's order, in the decrees. I read the response brief that was filed by Mr. Rial today. In his brief, he cites the provision from the court's order that's paragraph 10, but then he clips the sentence with his quote and leaves out the part that the mayor has been removed from office, and then continues on for multiple pages saying that there's no reasonable interpretation that says that the mayor was actually removed from office. Well, I think not only is that contrary to a plain reading of the court's orders, but it's also contrary to extended conversation that the parties have had with the judge about the status of the town governance, the fact that the mayor has been removed from office, and Mr. Rial asked multiple questions of Your Honor to be clear as to what the court's ruling was, and the court was clear that Mr. Bassett had been removed from office. So what's important about this meeting is that the court's order that was filed on Friday the 30th was served to Mr. Bassett through his duly authorized attorney, Mr. Mackey. That was his representation on the record. So he got a copy of it, or is deemed to have gotten a copy of it through his attorney. Mr. Rial also received a copy of that order, and I listed the service contact sheet as Exhibit 3 to my motion. So they had notice of the order and an opportunity to comply with the court's order. Instead, what they chose to do is to intentionally and willfully disobey and disregard the court's order by allowing Mayor Bassett to participate in the meeting. In the meeting, the interveners who are present before the court today and can provide direct testimony on the issue is that they objected to Mr. Bassett's participation. They told the town attorney that there was a court order and Mr. Bassett was restrained from participating. And Mr. Rial went on to counsel the governing body, including the interveners, that the court's order had no standing, that it didn't have to be followed, that it was erroneous, he didn't agree with it, and therefore it had no effect. That is a clear derogation of the rule of law. That is contrary to the system of justice that we have in America. The mayor or Mr. Rial had adequate remedies at law, which they could have exercised. They could have appealed, they could have petitioned to the Supreme Court, as they've now done. But instead, they chose willful disobedience because it was expedient to their interests, and it allowed Mr. Rial to become reauthorized to resubmit all his pleadings to the court, even though his authorization was contrary to the court's order. And the court's order is good as law. So this is the situation that we were presented with last week, and obviously the filing of my motion for contempt, in my opinion, was not filed 11th hour. It was filed as soon as possible after the contemptuous conduct, which was the Monday proceeding, November 2nd. I filed my motion on November 3rd. So I'm not trying to gain any leverage here. I'm just trying to make sure that everything that happens is above board and consistent with the court's decrees, and we haven't had that here. I think the issue for the court today is actually relatively simple. It's a determination of whether or not the contempt defendants, Mr. Bassett and Mr. Rial, complied with the court's order. If they complied with the court's order, well, then they won't be in contempt. But if they didn't, they are subject to contempt. The only question for the court to consider today, in my opinion, again, is whether the court is going to give me sanctions for civil contempt against these two contempt defendants, and whether the court is going to refer the criminal contempt for criminal prosecution. So the law is clear on this issue of contempt, civil contempt, criminal contempt. I've cited the cases in my motion. Mr. Rial cites similar cases in his response brief. What is important to note is that civil contempt is if the court is able to fashion a remedy that helps to accommodate or compensate the plaintiffs for the trouble of having to go through this process. The criminal contempt is the charge and the punishment for completed act of contemptuous conduct that's in clear derogation of the court's orders. In this case, the mayor's participation at the November 2nd meeting was a completed act of contemptuous conduct. Mr. Rial's counsel to the town governing body that they could ignore the court's order is a completed act of contemptuous conduct. And for those, criminal contempt is the appropriate action and the appropriate sanction. Obviously, Your Honor, you cannot award criminal contempt sanctions today because of Rule 93 and the criminal process that follows. But I do believe that unless Mayor Bassett and Mr. Rial can give the court an adequate explanation of why they were entitled to defy the order and allow Mr. Bassett to participate on the November 2nd special meeting, then I think they're in trouble because they clearly they disobeyed what you asked them to do. So I think that's where we stand here today. I would note, just to highlight to the court, that in its October 30th order, beginning on page 3, that the contempt defendants are in violation of paragraph 2, that the amended motion to set aside default judgment and summary judgment are denied. Paragraph 3, that the town's request for stay of judgment is denied, and that clearly suggests that the town knew that a judgment was in effect and they needed a stay to make it ineffective. Paragraph 8, that the default judgment against John Bassett remains in full force and effect, and I believe that that document speaks for itself. Paragraph 9, that the summary judgment against defendant John Bassett remains in full force and effect. Paragraph 10, that the town is required to hold a meeting under certain conditions. Paragraph 11, until such time as Robles, Rial, and Anaya, Mr. Rial's firm, is duly authorized, that they're restrained from filing any papers in this action. And I argue that Mr. Rial was not duly authorized in that November 2nd meeting for the reasons stated. And paragraph 12, until such time as the orders against defendant John Bassett are set aside or vacated, the town of Edgewood will be governed and operated by the remaining members of the governing body. I think that's self-evident that Mayor Bassett was no longer a member of the governing body because he'd been removed from office. So these, Your Honor, are the bases upon which I believe contempt lies. Now, one other note that's slightly ancillary but somewhat important because it shows a pattern of conduct is with respect to this special meeting. Under the Open Meetings Act, the town is required to provide 3 days notice of a special meeting. 3 days is 3 24-hour periods. That's 72 hours. The town noticed their special meeting to start on Monday at 10 o'clock in the morning. The court's order on October 30th was filed at 9:58 in the morning. So I would suggest to you that if the town had properly noticed the meeting, that means they got a copy of the order, they prepared the agenda, and simultaneously published it within 2 minutes in order to meet the deadlines required by the statute and the town's operating resolution. So I believe that the town meeting on November 2nd was a sham on multiple fronts. Thank you, Your Honor. I stand for questions.
Thank you, Mr. Terry. Mr. Terry, we could proceed with the summation for defendants, then if you want to proceed with your witnesses, we can proceed in that manner. Okay. All right. For defendant Rael, will that be you, Mr. Kennedy?
Yeah, Your Honor, we just heard Mr. Terry's opening statement. I'd like to make an opening statement.
That's what I just asked you, Mr. Kennedy. Will you be representing Mr. Rael today?
Yes, ma'am.
Okay, then, and for defendant Bassett, will be Mr. Lowry or Mr. Mack?
On the contempt charge, Your Honor, it would be Mr. Lowry.
Okay. All right, we'll allow Mr. Kennedy to speak on behalf of Mr. Rael, and then Mr. Lowry, then you can present your summary, and then we'll proceed with Mr. Terry calling his witnesses. You may proceed, Mr. Kennedy.
And that begs my first objection, Your Honor. There can't possibly be witnesses today. We are here noticed by this court. In fact, only the mayor's motion was noticed. But we are noticed for a hearing on Mr. Terry's motion. Here's the title of the motion. Expedited motion for order to show cause to hold and declare defendant Bassett and Marcus Rayon civil and criminal contempt. So if Mr. Terry wins everything in his motion, he gets an order to show cause. He doesn't get to put on witnesses. He doesn't get sanctions. He doesn't get a referral to the district attorney. He gets an order to show cause. At which point, Mr. Lowry and I get to conduct discovery, and we will be aggressively conducting discovery on this matter. And at some point in the future, no doubt the court will set the hearing. If the court even grants the order, we'll set the hearing for a merits hearing. And at that point, we'll have witnesses, and both sides will be able to put on witnesses. But at the present time, the court can't, and maybe I'm mistaking the court's position. Maybe the court just wants to have witnesses on whether or not she's going to grant the order to show cause, not on the contempt. We are not here on a contempt hearing. We are only here on a motion for the order to show cause. Once we understand if there is an order issued, once we understand what the allegations are, specifically delineated in the court's order to show cause, not Mr. Terry's motion, but in the court's order to show cause, then we can properly defend, we can properly take a focused discovery and proceed to a merits hearing, which will take, from my perusal of the record, will take more than 1 or 2 days. I would therefore address the motion for the order and suggest to the court that the court should not grant an order to show cause in this case for any number of reasons. First of all, we directly contradict and dispute all factual allegations made by Mr. Terry in his opening statement and demand strict proof of his factual allegations. The court should understand that what you heard were the allegations of Mr. Terry. It's not what happened at the town council meeting. the town council meeting was regularly conducted, properly convened, which we will be able to present evidence on at a hearing on the merits if this matter gets that far. But to give you an example of the posture of this case, frankly, I don't know how it got to this point, but just to give you an example, Mr. Terry argues in his opening statement that the November 2nd meeting of the town council, Mayor Bassett is not supposed to be able to participate based upon the default judgments, which he says, these are his words, he says, well, that's self-evident. That's not self-evident. A default judgment is not self-executing. If a party has a default judgment taken against him or her, it is then up to the prevailing party to enact the proper orders and remedies to get the relief that they ask for. A default judgment means nothing more than someone didn't answer and they don't get to defend. But the party has to go on to execute on the judgment itself. And all we have, and a further example of this is business about count 2 somehow having some force and effect to make sure that Mr. Bassett's not the mayor. If the court will recall, count 2 was a petition for a declaratory judgment. The only relief that the court could possibly have granted at any stage of the proceedings on that count was a declaratory judgment. And it's my understanding that the court did grant a declaratory judgment. And here's what the court granted. Here's what the court said. The court finds and declares, and I'm citing from the October 15 order, the court's order. The court finds and declares defendant John Bassett is deemed guilty of malfeasance in office for violating the town of Edgewood's nepotism ordinance. Number 3, defendant John Bassett is subject to dismissal and removal from office as mayor of the town of Edgewood. Number 4, defendant John Bassett is subject to punishment for a misdemeanor criminal offense. All that means is, and Your Honor, I thought I understood that when Your Honor referred it to a special meeting on November 2nd, all that means is that the court has granted the declaratory judgment. It has no other force and effect. It has no force and effect. It just declares the status of the parties. The only way to remove an elected municipal official from office in the state of New Mexico is to follow the procedures delineated by the legislature in 3-10-7. That's the only way to do it. You can't do it with a declaratory judgment. And Your Honor didn't do it. Mr. Terry thinks she did it, but Your Honor didn't do it. All Your Honor did was deem him guilty of malfeasance, subject him to dismissal, subject him to punishment for a misdemeanor. Only the town council, upon a complaint filed in a district court, can remove a mayor from office, or can move for it to remove the mayor from office under 3-10-7. And so, contrary to what you heard in Mr. Terry's opening statement, the October 30 order paragraph 10 does not remove the mayor from office. All Your Honor has ever done to follow up on the October 30 order is to issue a document that I have seen, and I must admit I'm having trouble believing I saw it, but I did see it. It was called a writ of execution. And the writ of execution was a statement by this court under the writ that Mayor Bassett was not to be removed from his office until 4:30 p.m. on November 4th, 2020. Now, why the court issued a writ of execution in a matter of this nature, I have no idea. I have no idea. But the court did. And the language in the writ is such that any reasonable person, any reasonable lawyer reading that document would understand that minimally Mr. Bassett is mayor until 4:30 p.m. on November 4, 2020. So why would the court how can you do that? It's not possible. It's legally impossible. It's factually impossible. I would urge the court to deny the motion for order to show cause, to not issue an order to show cause, and let the litigation proceed in a normal and calm manner, and put an end to this kind of lawyering by Mr. Terry, whereby everything is self-evident and everything's self-executing, and he never has to do anything except get default judgments. That's not the way the law works, Your Honor, and that's not the way you remove a mayor. It's not the way anyone removes a mayor. That's all I have for now. We ask the court to deny the motion.
Thank you, Mr. Kennedy. Mr. Lowry?
Your Honor, Mr. Bassett would join in all the arguments made by Mr. Kennedy regarding the position. I would just emphasize that under no circumstances had Mr. Bassett or counsel, for that matter, entertained the court taking evidence today. I mean, if you look at the court's notice for hearing, you set this for 30 minutes. I mean, and I agree with Mr. Kennedy that we would get the right to get discovery should the order consider doing what the motion requested, was to enter an order to show cause, and that's what the relief was requested. So personally, I saw this as a purely procedural hearing where we would understand whether this court thought it was appropriate to move forward with procedurally with an order to show cause or not. But for all of the reasons Mr. Kennedy just articulated at length, we think not, that the court should not move forward with an order to show cause. And again, for some of the reasons that I discussed earlier, I mean, Mr. Terry has not filed a sworn motion, a verified motion, to even put this in order. And the fact is, like Mr. Kennedy said, everything seems to be self-evident to Mr. Terry, and he said something that really kind of struck me, that I'll go back to his argument, but he was talking about, the parties, and he said that there was, just this, pardon me for a second here, but it just implied that there was this complete failure of the defendants here to abide by New Mexico law. And it's just, when you see time and time again the failure to serve pleadings, the failure to follow statutes, the failure to make a verified motion for contempt that's required under the case law of New Mexico, that I don't think that we're in a position for the court to move forward on an order to show cause. And it strikes me as fundamentally bizarre that Mr. Terry is contemplating taking testimony from Mr. Bassett while dangling the prospect of criminal contempt proceedings in front of him. I mean, Mr. Bassett would have no alternative but to invoke his Fifth Amendment rights, not knowing where the court's thoughts are on the issue of civil versus criminal contempt. And on that point, Your Honor, I would just add that this, at its core, is a criminal contempt motion. I don't think the plaintiffs have standing to effectuate some kind of personal relief that they were entitled to that would be vindicated by an order to show cause. And if you look at the case law in New Mexico, what they're really seeking, in their view, is the court to enforce the authority, as Mr. Kennedy talked about, the declaratory judgment that the court entered in a manner that doesn't comply with statutory law. But not only that, but that's the essence of the contempt that they're seeking, is they're saying, oh, these individuals willfully violated the court's orders, which is a purely criminal contempt proceeding. It's nothing civil about it. And so, Your Honor, I think at best we move forward today with an understanding whether the court's going to issue an order to show cause or not. And that to have evidence taken today when we're not prepared. This court noticed this hearing for 30 minutes and we're already an hour into this proceeding. It's just fundamentally unfair, which circles back to the motion for disqualification that we filed earlier. The proceedings with regard to Mr. Bassett have been fundamentally unfair. And I think, as Mr. Kennedy said, everybody needs to take a deep breath and litigate this case in a manner that comports with the appellate law in this state, and at best allow the parties to file the pleadings necessary and allow them to comply with due process to protect their fundamental rights under Article 2, Section 18 of New Mexico's Constitution. Thank you, Your Honor.
Thank you, Mr. Lowry. Mr. Terry?
Yes, thank you, Your Honor, and I'll keep it really short. Point number one. I think it's very important that we clarify who is representing whom and who is entitled to say what. On Mr. Kennedy's presentation, I understood from his entry that he represents.
Your Honor, I object to this. This is not true rebuttal. I never made any argument about who's representing who. This is not rebuttal. That's a true rebuttal.
All right, Mr. Terry, is your rebuttal or your statements going towards what has been stated by the defendants? If they are, please limit to that.
Sure.
Terry?
Issue number one, and then moving on. Conflict of interest. Mr. Kennedy is presenting arguments on behalf of Mayor Bassett. I believe he represents Mr. Rael.
Your Honor, I object to this. We never made any argument regarding the representation, whether it was joint or separate or cooperative or not. This is way beyond anything I said or Mr. Lowry said. I ask Your Honor to rein this attorney in, please.
Okay. And Mr. Kennedy, just for clarification, I didn't see an entry of appearance filed on your behalf today. So if you could, for the record, state, my understanding is you are here representing Mr. Rael here today on behalf of the town of Edgewood. Is that correct?
That's true, Your Honor. My entry was filed this morning.
Okay. Thank you. Thank you for clarification. All right, Mr. Chair, with that, you may move on.
Okay. Point number two. Mr. Kennedy has requested strict proof of the allegations that the plaintiffs raised in their motion. I would argue to the court that strict proof has already been given through admission. Mr. Rael filed a response to the plaintiff's motion today. He filed it in his own name. It bears his electronic signature. In that document, he has admitted the facts as alleged by the plaintiffs, namely that there was a meeting, that the mayor participated, and that he gave counsel that the court's orders were subject to debate. And I argue that that is not true, but that's for the judge to decide. Nevertheless, if you look at Mr. Rael's pleading filed with the court, it provides all of the factual predicate and the admissions that are necessary. Point number three. There's been some discussion, and it gets brought up from time to time in various arguments of the parties about the process to remove the mayor and this contention that there's a singular process under the municipal code that requires the governing body to do something, and that hasn't happened. There is also a separate and alternative procedure. It's the quo warranto statute. It is Chapter 44, Article 3, Section 4. That is a separate alternative statutory procedure for the removal of a public official from office. So with that, I believe we can proceed. Point number four, and I think this is particularly important, that contempt is an inherent power of the court. And because it's the inherent power of the court, Your Honor, you can handle this matter in any fashion that you deem fit and appropriate. If there are any defects in my pleading, I don't believe that there are, but some have contended that there are. The court can cure those defects because you can take up this matter sua sponte. All by yourself, you don't need me. And in fact, it is your order that I am contending was not followed. So I believe that the action lies with the court as opposed to the plaintiffs. We just brought the notice to you. Thank you, Your Honor.